the Supreme Court of Canada has submitted a request for a definitive verdict against Ripple. The Securities and Exchange Commission is proposing a civil penalty worth a total of $876 million today. This punishment will be imposed as a mandatory action in order to fulfill the requirements. There is a high probability that this will serve as a deterrent for Ripple and other organizations to refrain from committing violations of a similar nature in the future. In what way does the motion inquire? Ripple has a long history of violating securities regulations, totaling $1 billion, and this action brings attention to that past. Ripple was primarily accountable for these violations as a result of the infractions that occurred, thanks to the fact that it offered and sold XRP to institutional buyers and other counterparties without first registering the transaction. Not only are severe punishments and the recovery of money required, but they are also necessary in order to ensure that illegal behavior is stopped and to discourage future behavior. In addition, the Securities and Exchange Commission (SEC) draws attention to Ripple's failure to accept responsibility for its infractions. Ripple's portrayal of the court ruling as a complete victory and its lack of transparency about its business activities serve as illustrations of this refusal. Despite receiving legal counsel regarding the promotion of XRP as an investment and its cash sale, Ripple chose to disregard this advice, suggesting a deliberate attempt to circumvent the law. Both of these actions are evidence of Ripple's refusal to accept responsibility for the crimes it has committed. The Securities and Exchange Commission (SEC) maintains that the only way to get Ripple to change its behavior and comply with the regulations imposed by security is to impose penalties and repay any profits that were obtained in an unlawful manner. The requested relief not only addresses the market but also aims to prevent further violations that could deprive Ripple of its rights to illicit benefits. Fred Rispoli, a legal expert, provides an explanation for the current argument and legal struggle that is taking place between Surge Labs and the United States Securities and Exchange Commission. In addition to this, his research sheds insight on potential significant developments the scenario may undergo. Ripple should be penalized approximately $2 billion, according to a motion submitted by the Securities and Exchange Commission of Canada. This motion provides insight into the consequences that this could have for Surge and the cryptocurrency industry as a whole. Her speculations strongly suggest that the Securities and Exchange Commission's action will significantly impact both the Ripple market and the cryptocurrency industry overall. This is despite the fact that we anticipate obtaining additional information from new papers. According to Rispoli, there are two potential outcomes: either a speedy and peaceful resolution following the decision of the court or a drawn-out legal battle with restraining orders. Rispoli provides an analysis of the situation and its potential consequences. Fred Rispoli, a well-known advocate of XRP, contends that the intricacies of the case are essential in judging the gravity of the charges that the SEC has made against Ripple. This is despite the fact that no Ripple or XRP enthusiast will ever be able to know the conclusion of the litigation. The SEC is calling for the imposition of actual damages on retail investors, despite Ripple's inability to provide proof to support this claim during the motion's substantial dissection process. Furthermore, the SEC is demanding the award of actual damages to retail investors. This has undoubtedly already had a number of repercussions for the market, particularly for individual investors and the rest of the ecosystem. The sale of discounted XRP to institutional purchasers is garnering special attention. This has undoubtedly already experienced a number of implications. There is little doubt that these repercussions will occur in the future, but there are also concerns about Ripple's XRP sales once the lawsuit concludes. The San Francisco-based company's revenue generation methods and the types of contracts it enters into with institutional buyers have raised several issues. Given the ongoing legal struggle, Fred Rispoli's study offers valuable insights into potential impacts on the Surge and the cryptocurrency market. In his most recent opinions on X, Rispoli's perspective offered some commentary that shed light on the complexities of the scenario as well as the outcomes that could occur. Despite the fact that this pundit has a tendency to exaggerate his statements over the company's institutional sales practices, Bill Morgan has brought up the prospect that Ripple may be subject to legal concerns as a consequence of the continuing legal struggle with the United States Securities and Exchange Commission. We should consider this in light of the Ripple project's impact on costs and other related issues. The Securities and Exchange Commission (SEC) released a summary of Bill Morgan's graphic concerning remedies 2 days ago. Today marked the public release of the formal discovery. Based on the historical interview, we have learned that the SEC side has requested a total of $7 billion, on top of all other sums, in response to the damages and fines imposed following the release of this statement. Through his Twitter account, Bill Morgan expressed his worries regarding the claims made by the SEC regarding Ripple's institutional activity. Morgan brought up the Securities and Exchange Commission's SEC accusation that Ripple harmed other institutional investors by offering substantial discounts. As a result of this loss, the Securities and Exchange Commission (SEC) reports that institutions have incurred damages totaling $480 million. Furthermore, the market price of XRP is declining due to discounted sales to specific institutional investors. I need to allocate time in the future to scrutinize all the assertions made in the SEC brief, along with the supporting data. We need more specific details. Morgan asserts that this statement raises the possibility of a class action lawsuit from any and all other investors who did not receive the discounts on their investments. If this scenario plays out, a number of different organizations might file themed lawsuits against Ripple, arguing that the company's refusal to reveal discounts during the process of purchasing anything caused them to suffer some kind of loss. There must be a convincing case for the timing of the discounts, according to Morgan, in order to show causality and file the themed cases. Morgan argues that this is necessary in order to file the themed cases. The Securities and Exchange Commission's designation of Ripple sales to institutions as investment contracts implies the need to declare discounts in the event of registered sales. This particular feature puts a focus on the importance of transparency in Bitcoin transactions while also adding an additional layer of complexity to the procedures that are taking place in court.